Hello, and welcome to the Ministry of Government Relations webinar on discretionary land uses in Saskatchewan. In this webinar, we will examine legislation and zoning bylaws, what discretionary uses are, how to process a discretionary use application, Council's considerations and criteria when making decisions on discretionary use applications, an applicant's right of appeal on discretionary use decisions, and common myths related to discretionary uses. The Planning and Development Act 2007 is the legislation that allows municipalities in Saskatchewan to undertake land use planning. The Act sets out the minimum standards for planning documents and also includes a variety of optional tools to assist municipalities in addressing complex development challenges. There are 3 regulations created under the authority of the Act: the Dedicated Lands Regulations, the Subdivision Regulations, and the Statements of Provincial Interest Regulations. The Dedicated Land Regulations governs how publicly dedicated lands such as municipal reserves and environmental reserves may be used, as well as how money from dedicated lands accounts may be collected and spent. The subdivision regulations contain the review criteria for processing applications to subdivide new parcels of land. The Statements of Provincial Interest Regulations contain 16 policy areas where the province and municipalities have a shared interest. The SPI is particularly important when discussing zoning bylaws, since every planning document is required to incorporate the statements insofar as is practical. The term planning documents refers to district plans, official community plans, and zoning bylaws. This webinar will focus on the relationship between the official community plan and the zoning bylaw. If a municipality has adopted a district plan to function as their official community plan, or if they have a basic planning statement from before 2007, those are considered to be an official community plan to apply the Act. An official community plan is a statutory plan that contains the long-term vision and goals for a community in the form of policy statements. The plan may also contain guidelines for using specialized zoning tools such as contract zones and holding provisions. The zoning bylaw is a primary tool for implementing the official community plan. It does so by organizing land uses and development to meet broader community objectives. Let's examine the zoning bylaw in more detail. The purpose of a zoning bylaw is to organize the use of land for the health, safety, and general welfare of the entire community. Historically, this meant separating incompatible land uses, such as high-polluting industries, from where people lived. Zoning has evolved over time to become more complex than just the separation of land uses, with the intent to go beyond health and safety to create amenities and a high quality of life for the inhabitants of a community. A zoning bylaw organizes development by dividing a municipality into zones using the map attached to the bylaw. In each zoning district, there's a list of permitted land uses that can be established in the zone. There may also be a list of discretionary land uses that may be established in those areas with council approval. Any land use which is not listed as either permitted or discretionary is considered prohibited in that zone. Each zoning district may prescribe development standards for either the entire zone or for each land use individually. For example, development standards may include building setbacks from property lines or maximum height. To better understand discretionary uses, we must first understand how land uses are chosen for inclusion in each zoning district. Each zoning district will have a purpose or intent which guides the types of land uses and development standards that apply. For example, a low-density residential district may have a purpose to accommodate a low number of residential dwellings and other compatible uses in areas with large lots and abundant open space. To align with this purpose, permitted uses may also include 1- and 2-unit dwellings. The development standards for the zone may require the protection of open space by limiting the maximum amount of area the buildings can cover on a lot, or require increased building setbacks from property lines to maintain open space between buildings. Discretionary uses are land uses which may align with the broader purpose or objectives of a zoning district, but may not be suitable at every location within the district. Using our previous example of a low-density residential district, commercial daycares may meet the purpose of the zone as a compatible use, but may not be appropriate in all locations due to their impact on traffic. The low-density residential district may list commercial daycares as a discretionary land use, allowing a more in-depth assessment of the proposed locations for suitability. Making land use discretionary is a way of regulating aspects of an operation that are likely to impact a larger area. Discretionary uses should never be seen as a way to regulate people or users of an operation. Even though discretionary uses are reviewed individually for their suitability with the area, the Act requires a certain level of predictability in how discretionary uses are reviewed. If a municipality chooses to include discretionary uses in its zoning bylaw, the bylaw must identify review criteria that the council will consider in their decision-making. These may include criteria such as the proposal conforms with the policies of the official community plan. It can be economically serviced by existing services such as water and sewer and does not require expensive servicing upgrades. And the proposed use will not cause negative impacts on existing land uses in the area. The zoning bylaw should also include development standards or conditions that council can assign to a discretionary use as part of their decision. Standards and conditions should address the aspects of the use that may affect the wider area. Examples include features of the lot and the placement of buildings on the lot, entrances and exits to the property by people and vehicles, safeguards to avoid noise, glare, dust, and odor, and landscaping and screening requirements, parking, lighting, and signage. Once the municipality receives an application for a discretionary use, the development officer will want to confirm that all necessary information has been submitted. Relevant details of the operation may vary depending on the type of land use. Using our commercial daycare as an example, council may want to know how many children will be in their care at one time, since this impacts traffic volumes and noise. Any details that relate to the scale or intensity of the land use should be included with the application. Since discretionary use applications can take more administrative time to review, most municipalities have a higher application fee for discretionary uses. These fees are normally collected at the time of application to avoid any issues with non-payment. The Act requires that public notice be provided before council's consideration of a discretionary use application. The Act requires that, at a minimum, notice be given to property owners within 75 meters of the subject property at least 7 days before the council meeting. The zoning bylaw may contain procedures above and beyond the minimum required in the Act. The review and report from the development officer should provide the important information that council will need for deciding on the application. Information typically includes background information on the proposed location, example, orientation on the block, historical uses, an analysis of how the proposal aligns with the discretionary use criteria in the zoning bylaw. Example, what is the capacity of the services in that area? Will services need to be installed or upgraded to accommodate the proposal? A summary of public comments received as of the date of the report. And if the development officer is recommending approval, if there are any recommended conditions for the approval to mitigate potential conflicts with adjacent uses, like landscaping requirements. Council's consideration of a discretionary use application should follow a similar process as the development officer's review. Council may find it helpful to answer the following questions. What aspects of the proposed use will likely affect a larger area? Is the proposed location suitable for this use? How does the proposal align with the bylaw requirements, including review criteria in the zoning bylaw? And what are the public's comments relating to this proposal? Council has several decision options when reviewing a discretionary use application. They may reject the application, approve the application subject to any development standards and conditions identified in the zoning bylaw, or approve the discretionary use for a limited time if the time limit is authorized in the zoning bylaw. In any case, council must notify the applicant of the decision in writing, including whether they have the right to appeal the decision. The Act provides a limited right of appeal on discretionary use decisions. The applicant may only appeal development standards and conditions attached to an approval on the grounds that the standards exceed what is necessary for meeting the objectives of the bylaw. For example, if council imposes landscaping and buffering requirements that are not authorized by the zoning bylaw, the applicant may appeal safety requirements. Council should apply standards that are consistent with the zoning bylaw and are necessary to meet the objectives of protecting the health, safety, and welfare of the residents. There are many myths and misconceptions related to discretionary uses and the review process. Let's look at a few common ones. 1. All uses can be discretionary in a zoning district. There is a common misconception that council can have greater control over development by listing all land uses as discretionary. However, the Act requires at least one permitted land use in each zone. If council would like to regulate development in an area more closely, other tools such as direct control districts may be more appropriate. 2. Discretion means council can make any decision they want. The term discretionary is often associated with the ability to make decisions on a case-by-case basis. While discretionary uses are reviewed individually, the reviews and decisions should be based on predetermined criteria and conditions contained within the zoning bylaw. 3. Council needs to know who will be using the property to make a decision. While discretionary use applications typically require submission of additional information about the operation, there's some information that is not relevant. The purpose of a zoning bylaw is to regulate land use activities, which may affect the community, not regulate the users of the property. Council should be aware of what information is relevant for making a land use decision. This concludes the webinar on discretionary uses. If you have any questions about the content of this webinar, please contact the Community Planning Branch using the information shown on screen. Additional resources such as the Zoning Bylaw Handbook may be found on saskatchewan.ca. Thanks for watching.